Resuming debate, reprise de débat. The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker, and I rise this evening to speak on the report of the Standing Committee of Justice with respect to Bill C-242 introduced by the honourable member for London North Centre. Madam Speaker, Bill C-242 seeks to establish a criminal code offence for torture in the non-state realm. Presently, the only criminal code offence for torture lies in Section 269.1 of the Criminal Code, which deals with state torture. Madam Speaker, at this time I would like to thank the honourable member for London North Centre for his hard work and for his efforts to bring awareness to the important issue of non-state torture and for seeking to try to do something about it by bringing forward Bill C-242. Madam Speaker, at second reading debate, I spoke in favour of Bill C-242. I did so notwithstanding the fact that the evidence was clear in terms of reviewing the law, that there is no clear gap in the law in terms of prosecuting and convicting individuals involved in torture offences. Those offences that cover torture include, among other things, aggravated assault, aggravated sexual assault, forcible confinement, kidnapping, and so on. But I nonetheless supported Bill C-242 because I believe that it is a well-intentioned bill, and I take seriously the issue of torture. And I, in that regard, believe that it certainly merited moving to the next stage in the legislative process, namely to committee for further study and review. That study and review did take place by the Justice Committee, of which I am a member of. And upon participating in that review, I now concur with the report of the Justice Committee, which is to not recommend that Bill C-242 move forward. Not because it isn't well-intentioned, and I certainly acknowledge the fact that there is certainly symbolic value, Madam Speaker, to calling a torturer what a torturer is, and that is a torturer. But, Madam Speaker, good intentions and symbolism do not always make good law. In this case, Madam Speaker, I respectfully believe that Bill C-242 would not make good law. And while my time is limited and do not have sufficient time to go through all of the issues with Bill C-242, I would like to highlight a couple of issues with the bill. Madam Speaker, one of the issues with Bill C-242 is it could complicate the prosecution of cases involving torture and could lead to inconsistent sentences for similar crimes. Take aggravated assault, for example. Under the criminal code, aggravated assault is defined as an offense involving wounding, maiming, disfiguring, or endangering the life of another human being. Madam Speaker, there are all sorts of circumstances involving acts of torture that could easily fit into one or more of the categories of wounding, maiming, disfiguring, or endangering the life of another human being. Under the criminal code, the maximum penalty for aggravated assault is 14 years. Under Bill C-242, the maximum penalty for the proposed torture offense would be life imprisonment. Therefore, Madam Speaker, if Bill C-242 were passed, it could mean that someone who, for example, severely maimed an individual could be convicted of aggravated assault and sentenced to 14 years behind bars, whereas someone who committed a similar offense could be convicted under the torture offense and receive a sentence of life in prison. This is, Madam Speaker, just one example of an instance where it could be more difficult for the prosecutor to prosecute a case and where the outcome of similar cases could result in different sentences. Madam Speaker, additionally, there is inconsistency between the life sentence under Bill C-242 and the 14-year sentence, the maximum 14-year sentence under Section 269.1 of the Criminal Code, which deals with state torture. It therefore raises the possibility that if, for example, a police officer or member of the Canadian Armed Forces engaged in a crime involving torture, that the prosecutor would be faced with the position of electing to proceed under the new offense under Bill C-242 or the existing offense under Section 269.1 of the Criminal Code. If the prosecutor wanted to have the maximum sentence, they would likely proceed under Section 269, under the new section under C-242. The difficulty, Madam Speaker, with that is if the prosecutor proceeded under the new offense rather than Section 269.1, it could be argued that Canada would not be fulfilling its international obligations under the Convention Against Torture, which calls upon Canada to hold state officials accountable under international law codified by Section 269.1 of the Criminal Code and not the new section under Bill C-242. Now, Madam Speaker, the member for London North Centre at committee had suggested that perhaps the sentence be reduced from life down to 14 years. While, Madam Speaker, that would largely address issues of inconsistencies in terms of sentencing for similar cases and similar crimes, it would not take away complexities in terms of prosecuting cases involving torture that would be created as a result of Bill C-242. Madam Speaker, if one looks, for example, at aggravated assault, it is necessary when trying to establish intent that the Crown need to prove that the accused intended to commit an assault. Under Bill C-242, it would not only be necessary to establish intent with respect to the torturous act, but it would also be necessary to establish intent in terms of inflicting pain on the victim. And not only would it be necessary to establish that intent to inflict pain and necessary to establish that an intent to intimidate or coerce an individual, it would be necessary to establish that the individual who had pain inflicted upon them suffered severe and prolonged pain. And on top of that, Madam Speaker, it would be necessary to establish not only that a torturous act was committed against an individual, but that the torturous act was committed repeatedly. Unfortunately, Madam Speaker, repeatedly is not defined under Bill C-242 and therefore would be subject to judicial interpretation, creating uncertainty. Madam Speaker, in closing, I will simply say that while Bill C-242 was a well-intentioned bill, it creates uncertainty in the criminal code. It will create further complexity in terms of prosecuting cases involving torture. It raises legal and interpretive problems for the courts, and it arguably could undercut Canada's international obligations under the Convention Against Torture. It is for those reasons, Madam Speaker, that I regretfully must stand in opposition to Bill C-242. Thank you, Madam Speaker.
Resuming debate.